You're watching All Rise News on the Legal AF channel of the Midas Touch Network. And there was an astonishing story very recently in NBC News. I've been a legal journalist for the better part of 2 decades, and I know how rare it is to get a federal judge to speak to you in an interview. Well, NBC News spoke to a dozen federal judges recently, 10 of whom lobbed direct criticism at the Supreme Court of the United States, saying that the court is putting them in danger, in physical danger, through shadow docket rulings that are overturning them with little explanation, seemingly validating the Trump administration's attacks on them. Going to talk about that today with a top Supreme Court expert. Very happy to welcome University of Michigan law professor Leah Litman. Leah, thank you for joining us to discuss this incredible reporting. What was your first reaction? Before we begin, Leah Litman is the author of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. So what was your reaction? I had a very strong reaction, of course, based on my experience as a legal journalist to this NBC News reporting. What was your first reaction to this report?
It was jaw-dropping. It's nice to know that a lot of apparently lower federal court judges have the same opinion of the Supreme Court that I do, utterly lawless. But it's a stunning piece, and it took me aback for several reasons. One, as you note, it's so rare for federal judges to actually talk to the press. The fact that they got so many federal judges to talk to them itself is significant. Second, the substance of what they said is remarkable. You know, it's one thing to have federal judges talk to the press about threats to the federal judiciary or give a bunch of bland remarks about judges being committed to the rule of law. It is entirely another to have the inferior federal courts talking to reporters about the mess that is the Supreme Court and the jam that the Supreme Court is putting so many lower federal courts in trying to decipher what they mean on the shadow docket, in fanning the flames in the Trump administration's war and attacks on the lower federal courts. I've never seen anything close to this. And I want people to take away from this not that the lower federal courts are doing something untoward, right? And that's what we should focus on. Instead, the message to take from this is how severe and serious the problem with the Supreme Court and what they are doing vis-a-vis the lower federal courts is, that these judges felt the need and willingness to speak up about it publicly.
Let's delve into what that problem that they diagnose is. And I agree with you. This feels like an Article 3 judge rebellion here. That you mentioned the shadow docket, and it's the crux of their criticism, also known as the emergency docket. For folks who are watching and might not be familiar with those terms, what is the shadow docket, aka the emergency docket?
Well, Brett Kavanaugh also proposed a new name for it yesterday, the interim docket. So let's get all of the names on the table. But the interim/emergency/shadow docket refers to the set of emergency applications that the Supreme Court gets on a docket that doesn't entail full briefing, oral argument, or necessarily opinions with explanations. So the kind of shadow docket that these judges are talking about involves the Trump administration's use of the shadow docket, where the Trump administration will go to the Supreme Court asking for emergency relief, typically in the form of a stay, to put on hold, to pause a lower federal court ruling that has gone against the administration. And what they are asking for is for permission from the Supreme Court to implement a policy that a lower federal court has declared illegal while the litigation against that policy remains ongoing. So just to put this concretely, you know, the Trump administration ended or attempted to end temporary protected status or TPS for many different categories of migrants. This is a form of relief from deportation or removal that effectively gives you legal authorization to remain in the United States. And a lower federal court had declared the Trump administration's withdrawal of TPS for almost 600,000 Venezuelan migrants illegal. So what did the Trump administration do? They ran up to the Supreme Court and asked for a stay of that decision, and they got one. So what that means is, even though, right, in the last week, the Ninth Circuit, the Court of Appeals, agreed with the lower federal court that the withdrawal of TPS is illegal, still the administration can go ahead with withdrawing TPS until the Supreme Court agrees with the Court of Appeals, because by pausing the lower federal court injunction, again, what the Supreme Court has said is go ahead, implement this policy. It doesn't matter that the lower federal courts declared it illegal, right? It's only going to be up to us, right, if you can't actually implement the policy.
And there were, the NBC News crunched some numbers here, and they said that, quote, since Trump took office again in January, his administration has asked the Supreme Court 23 times to block lower court rules on an emergency basis. And they put a chart in their story showing that Trump won 17 of those battles. And if you look at the lower court rulings, he's losing case after case after case after case. You mentioned temporary protective status. What were some other significant emergency docket victories for the Trump administration?
So the Supreme Court allowed Donald Trump to fire the heads of multi-member commissions in the National Labor Relations Board, the Merit System Protection Board, the Consumer Product Safety Commission in violation of federal law. So those were significant victories. The Supreme Court also paused lower federal court rulings that had declared the Trump administration's rescission of hundreds of millions of dollars in National Institutes of Health grants illegal, thereby allowing the administration to continue to withhold that funding. That was an incredibly significant ruling. So too was the ruling that allowed the administration to move forward with these third country removals, where they send people to countries other than their countries of origin or nationality. The Supreme Court also paused a lower federal court ruling that had blocked the administration from carrying out the Alien Enemies Act expulsions to El Salvador. So they have gotten so much off the shadow docket. And that doesn't even include, right, allowing them to implement their ban and expulsion on transgender service members. That doesn't include, right, ending different forms of temporary protected status for different groups. So they have really been running the tables at the Supreme Court when it comes to implementing their policies.
And some of the rulings that you're mentioning now, they have been from judges appointed by presidents from both parties. One was a Reagan appointee who was responsible for the NIH grants that you spoke about. One of the criticisms about these emergency docket rulings is very often, because they're on an emergency basis, the Supreme Court doesn't say why they're ruling in a certain way. Can you explain a little bit more about that?
Yeah, so it's basically up to the Supreme Court whether they provide an explanation or how much of an explanation they provide when they choose to issue these orders staying lower court opinions. Sometimes they offer some explanation. When they allowed Trump to fire the heads of multi-member commissions, they wrote a few sentences explaining why they thought he could do so. Sometimes they offer zero explanation, like they did when they stayed the lower court decision on third country removals. So it really spans the spectrum as to whether there is an explanation and how much of an explanation. I think the difficulty has arisen because, honestly, at least until a few weeks ago, it was unclear whether these shadow docket orders were precedential in the sense that lower federal courts should be applying them to other cases. I mean, several years ago, in remarks to Notre Dame Law School, Justice Alito said these shadow docket orders, right, there aren't precedential, right? They're not going to control the outcome of these cases. Well, just a few weeks ago, Justices Gorsuch and Kavanaugh were lecturing the judge in the National Institutes of Health case, the Reagan appointee you mentioned, for allegedly defying the Supreme Court's order in the case about Department of Education funds. And so the landscape seems to have really shifted in what the Supreme Court thinks and what they are telling lower federal courts to do with their orders. And part of the difficulty arises when there's no explanation. I mean, how on earth are the lower federal courts supposed to know what they should be doing in other cases? They don't even know the reasons why the Supreme Court said this lower federal court in this other case got something wrong. And so that's part of the frustration. And in what I felt was one of the more revealing admissions from his remarks to the Sixth Circuit Judicial Conference, Justice Kavanaugh said, well, sometimes we don't issue rulings because we can't agree on the rationale. And so in that circumstance where they are issuing an unexplained stay because they can't agree on why the lower federal court got it wrong, how on earth are you possibly faulting the lower federal courts for guessing at what your secret reasons are and what the controlling secret reasons are?
And Justice Gorsuch actually at one point chided lower court judges, saying that they aren't following their emergency docket orders that are, as you noted, in many ways unexplained. Justice Jackson, very memorably in a dissent to one emergency docket ruling, described what is happening at the Supreme Court level as Calvin ball, where there are no rules that are used the same twice, but the rule always seems to redound to the benefit of the Trump administration. Can you explain Calvin ball for people who are not readers of Calvin and Hobbes?
Yeah. So Calvin ball is this game where, as Justice Jackson says, there are no rules, right? And because there are no rules, it allows someone to make up the rules as they go to declare themselves as always the winner. And what Justice Jackson is saying is the court, right, is just ruling for the Trump administration, not on the basis of law or reasons or rules. It's just because they think the Trump administration should win. And that is the rule. But of course, that's not remotely law, right? That's not the kind of rule we think about as, the thing that should be driving courts or the reasons why they should be justifying or explaining their decisions. So she's basically accusing her colleagues of being a bunch of lawless hacks who are in the bag for the Trump administration.
And very recently, Judge Burroughs from the District of Massachusetts ruled against the Trump administration trying to yank more than $2 billion in funding from Harvard University. In her ruling, she said, this is not Calvin ball, and there are rules. So this seems to be really boiling over. Eventually, one thing to note about the emergency docket rulings, they're just interim. The judges are ultimately going to have to explain their reasoning 1 year from now or so, right?
Yes, I mean, eventually, although honestly, it's possible they will end up dealing with a lot of this on the shadow docket, because it's possible, the Trump administration will go back up to the Supreme Court with additional requests to pause. And the Supreme Court will say, oh, there's this other procedural issue with the lower federal court ruling, so we don't actually have to weigh in on whether the administration violated the law. And instead, we'll just ask the lower federal courts to basically cycle through this all over again. You mentioned Judge Burroughs' ruling in the Harvard case. In addition to a callback to Justice Jackson's accusation that the Supreme Court is engaged in Calvin ball, unlike, Judge Burroughs says the district court, there was a pretty stunning footnote in which Judge Burroughs addressed Justice Gorsuch's and Kavanaugh's criticism of lower federal courts for defying the Supreme Court. The footnote began with saying, look, of course, right, I get you and I'm with you on this fact that lower federal courts are not free to defy Supreme Court decisions. Instead, this court submits that, it is unhelpful and unnecessary to criticize lower federal courts for defying the Supreme Court when they are trying to figure out the right answer when you're not giving us anything to work with. So again, we began this conversation talking about the NBC story. I mean, this too is a really judicial pushback, is putting it lightly.
Right.
But basically telling these guys to knock it off and try to take their jobs as seriously as the district courts are.
I agree entirely. This isn't an anonymous quote to a news organization. This is a direct clapback to the Supreme Court in a federal judicial ruling. And so to kind of get at the reason why frustrations are boiling over in the lower court level, can we talk a little bit about the threats that federal judges are facing? We hear a lot about pizza doxing, that judges are getting pizza deliveries to their homes in the name very often of a judge's murdered son, that there's a horrible, notorious case, Judge Esther Salas, whose son was murdered. And across the country, we're seeing and hearing about cases where other judges are getting pizza deliveries in the name of that judge's son as a kind of double note that, on the one hand, they know where the judges live, and on the other hand, it cannot be read as anything but a death threat.
Yes. And so I think several federal judges have participated in a convening over the summer in which they spoke about the kind of attacks and threats that these judges are receiving. And in addition to the absolutely horrifying, pizza deliveries to their homes or their chambers in the name of, Judge Esther Salas's murdered son, they are also receiving horrific voicemails, right, and written messages with explicit threats. During this convening, the organization played some voicemails that one of the district judges who ruled against the Trump administration received, and they are just explicit death threats.
We're going to come for him. His ass is going to prison. I double dare you to try to put charges on Donald J. Trump. You son of a bitch. And I wish somebody would fucking assassinate your ass.
That is, again, the context in which the Supreme Court's actions on the shadow docket should be understood, because when you have Justices Gorsuch and Kavanaugh fanning the flames and suggesting that the lower federal courts are basically engaged in some anti-Trump insurrection, of course that is going to embolden the Trump administration's attacks on lower federal courts, which of course only emboldens, right, Trump supporters' attacks and threats against these lower federal courts. Again, you noted in introducing this conversation that in that NBC story, a judge expressed concern that someone is going to die, right? Someone is going to get killed because of, no responsible higher level federal official intervening to tamp down on the escalating threats and war against the lower federal courts. And yes, so all of this is happening in this midst of rising threats of violence against the lower federal courts.
I want to highlight one statistic from that NBC News story. Quote, as of June, the U.S. Marshals Service, which protects judges, had reported more than 400 threat investigations this year. There has not been a prosecution that I'm aware of someone who threatened a federal judge. One judge told NBC News, quote, if the entire foundation falls out from under your house, it does no good to have a really well-insulated attic. It would sure be nice if someone had our backs. So I interpret this entire NBC News story, the entire willingness of 10 federal judges to speak to the news media about this as a loud, blaring bullhorn message to Chief Justice Roberts. And how do you think he responds to this? Does he acknowledge it at all?
He certainly hasn't acknowledged it at all. I think uncomfortably, it came out, I believe, the day after a Politico story, that reported from the Chief Justice's advisor, basically an apologia from the Chief Justice that he wasn't going to say more. right? It was a statement about the difficult position that the chief feels he finds himself in, saying, well, I only have a very small megaphone and I am trying to preserve in the long run, the independence of the Supreme Court and maybe the lower federal courts. And so it just seems like, in his view, right, he's not going to intervene. He is not going to make some statement about Donald Trump and his allies' attacks on the lower federal courts. And so I think these two stories sit pretty uncomfortably against one another. On the one hand, you have the Chief Justice saying almost preemptively, guys, like, I'm in a tough spot. I'm just not going to do anything. And this story from lower federal courts just begging him to try.
And with this extraordinary threat environment, with this extraordinary situation where federal judges are facing the kind of intimidation that they're facing when they rule against the Trump administration, do you find it absolutely remarkable that they continue to hold the Trump administration at the lower court level into account the way that they do, that we see this very incisively written, even defiant ruling by Judge Burroughs, rejecting the attack on Harvard University and academic freedom more broadly in a very strongly written ruling. Does this say something about how the Article III courts have been standing up?
I mean, I think it speaks very well of the lower federal courts, that they are still committed to trying to get the right answer. They're still trying to work with what the Supreme Court has gave them, and they are not standing down in the face of these threats. I think a lot of people, a lot of institutions are fearful right now of being targeted by the Trump administration, and I understand that. And these federal judges know what that is like. And I also understand that they have protections, that many of us do not. And yet, right, they are continuing to try to do the right thing and stand up for law and principle.
Thank you very much, Leah, for joining us. Once again, Professor Leah Litman from the University of Michigan, the author of the book Lawless, and top SCOTUS scholar. Very happy to have you with us today. You've been watching All Rise News here on the Legal AF channel. To get more videos like this one, hit subscribe. And if you want to go a little bit deeper, visit www.allrisenews.com to find the newsletter version of this story and stories like these. Thank you for watching.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.